Well, good morning. We thank you so much for joining us. We are excited that you guys are here today. And I should say good morning or good afternoon because there's some of you that are joining us that may be in other countries or in other parts of the world. I mean, the US. We are very excited to have you here on Red Worldwide's Co-working Live. And we have lots of participation today. I see that we've got a lot of people who have shown up and people who are available to put things in the chat. And we're just excited about that. Today, we're going to be talking about legacy. Today is Tuesday, and we try to really stick to our topics if we can. And so that is, something that we've been working on to make sure that we have available to people, everything that they need. And so I'm going to try to play a video for us this morning, just so we can, in a few minutes, because I want to try to bring people to the table in a way that everybody's on the same page, if I can. And that would mean that some of you have to be brought up to speed really quickly. To get to where some of our participants are because they've been working on their legacy for quite a while. So when we talk about legacy, I want to make sure that you guys understand what it is that we mean and what it does for you when you're able to really pay attention, to your wealth preservation concepts. And I know that for a lot of people, they don't really think about legacy the way that others do. But I want you to know that it's important for you to know there's no real hard starting point. You don't have to be a certain age to start thinking about your legacy. Your legacy is something that, can be really explored at any age. I mean, there's no time that's too late to start. There's no time that's too early to start. When you start thinking about what it is that you have that you're going to, leave in the earth realm or leave for your family members or, provide for those who are connected to you. I want you to be thinking about the fact that it's not something that is in a thought process of your past time or well, I'm going to be leaving this, but it's something that you build the legacy. That's something that you put forth as you are living, and everything you do, it's kind of like the internet. They tell you whatever you put out there on the internet is going to be there. Well, whatever you put into your legacy is going to be there. Okay. It's going to definitely be there. So we want to be thinking about that. When we're looking at all of the possible scenarios and things that you could do, think about the fact that you're building legacy, and every tool that you have, could be utilized to make sure that your family, people that you are connected to, people that you meet on the street, you could be doing something that could be helping their life to be better. And it just has to do with the thought process or your way of seeing things. So, I'll give you an example. As we were talking about legacy right now, today we're going to be talking about how we can leave a legacy to our children or to our family members, how we can actually pass things on to them quickly, quietly, and without the need for a process called probate. But I want you to also be thinking about there are some of the intangibles that you could be leaving as well that may not be something that you thought about. Okay. And so we're going to play a little bit of a video right now, and then we'll kind of jump back here in a few minutes. But when we're talking about intangibles, I write books, and some of the things that I've thought about is that for, the fact that I've put these books out here, they're going to always be here now. They're going to be here for people because of the places where I put the books. They're always going to be available to people in the future. And that's a living legacy that I have placed, in the earth that is not going to ever go away because I put it here in such a way that regardless of whether a person has an opportunity to get it in paper or get it in hardback, or for that matter, get it online, they have, or an audiobook, they have a way for them to have access to it. So thinking about some intangibles while we're thinking about the, things like money and our properties and things of that nature. But thinking about the fact that you also have, maybe a gift or maybe an idea or a concept that could change the way that people do business forever. That could be a public legacy that you leave it by just making a decision to share it. Okay. So let's watch our little video today and learn a little bit more about the Living Trust.
I've been thinking about estate planning, but I'm not sure where to start.
Estate planning is essential to ensure your assets are protected and passed on according to your wishes. Let's start by discussing probate avoidance.
What happens if I don't have an estate plan and suddenly pass away?
Without an estate plan, your assets will go through probate, a lengthy and costly court process that can be stressful for your heirs. The best way to avoid probate is to create a living trust.
What about passing on assets to my heirs?
A simple will provides clear instructions but does not avoid probate. Joint ownership and beneficiary designations can help avoid probate for certain assets, but a living trust is the best option for comprehensive asset distribution.
What about designating care for my minor children?
Naming a guardian in a will is a good start, but a living trust with a pour-over will is the best option for comprehensive care and financial management.
What about my business?
Succession planning is crucial for a business's future. A will or buy-sell agreement is a start, but integrating the business into a living trust with detailed succession planning is the best option.
I see. So, a living trust with a pour-over will is the most comprehensive option for estate planning.
Yes, a living trust provides probate avoidance, asset distribution, care for minor children, and business succession planning. It's the best way to protect your assets and ensure your wishes are carried out.
So when we're seeing this, a lot of times, I watch these videos, and even when I was making this one, I think about the fact that some people have never even heard of the concept of a living trust. They may not have been in a situation where someone they knew in their family, have ever use this particular process. And so when we've been having these sessions, we kind of talked a little bit about legacy last Tuesday, but I want to really kind of share this, or I should say Tuesday before last, because I was traveling last week. But I want to really look at this because when people are thinking about the word living trust, they probably don't necessarily understand the fact that the design of the entity, the living trust, is to be used while you're alive. Okay, it is really to be put in place as a revocable trust, meaning that you yourself can become the person that creates the trust. You can be the person who is the trustee of the trust, and you could also be the beneficiary. And so the person who creates the trust, the grantor or settlor, those are also names for people who are in that position of the creator of the trust. You now have the power to make the decision of what it is that the trust can and will do, within the guise of what the law says that you can do. Okay, so it's all you. It operates off of your Social Security number. You can transfer properties into it, and nothing will change in terms of taxes. You still will be able to take advantage of your homestead because it's still you when you transfer the property into your living trust. You could also still utilize that same living trust to direct things to your heirs. You can make specific distributions to your heirs. You may decide that you want to give one child a family Bible. You might decide to give the other, children a pair of earrings that you might have had, or something else, or maybe all the furnishings in your home, or anything else that might be, something that you wanted to structure to go to them. The living trust is really there to give instructions. And when you don't prepare one and you don't have this as a plan, then what happens is, even if you have a will, the probate court will have to, make some decisions for you that you could have made for yourself in writing inside of this particular document. So the will, even though you're putting it together, it does not give you the opportunity to utilize it in a way that makes sense. Okay, so I really want you to have that in your mind, because when you are thinking about the living trust, think about the fact that, I want to go back one. Okay, let's see if it'll let me do that. Nope, it doesn't. Okay. All right. So there we go. I really want you to be thinking about the fact that it does not give you the ability, to make the decision without utilizing the courts. It only gives you the ability to designate, but the courts get the final say, depending on how many heirs you have or what other bills might have propped up. So utilizing the living trust gives you a legal document that states who you want to manage and distribute your assets if you're unable to do so while you're alive, and who receives them when you pass away. The living trust helps you avoid the probate process, and it transfers the heirs to your heirs what you have that you've designated for them quickly and quietly. So it's very important that you understand that, okay? And so when we're talking about this, I want to kind of bring up or bring in, I should say, some information about our friend Alex. And so you guys might have remembered Alex because I use Alex in some other of our presentations. So Alex is 45, and he's recently started thinking about estate planning, about, what he should do for his public legacy. And as Alex has been thinking about this, what has cropped up is the fact that he owns a home, he has some investment accounts, and he runs, a small local business. He has 2 minor children, and he's aware, that he's got some things that may not be in order. Is that Gloria de Santiago? Oh, I'm so happy to see you. Good morning. Good morning, Gloria. And as he's thinking about these things, he is also aware of the fact that he hasn't taken any steps towards creating for his family, and he's like, well, I'm 45, I've got some time, and I probably, although I know I should probably do this, it's just, I just don't have the time, and I don't have the money, it's probably very, very costly. And so Alex has not gone out to even seek to find out if there's any way that he could do it, with his income, or with his, something that he might be able to do even himself, so Alex is in a position that a lot of people that we may know are in. And so we're going to talk to Alex and try to help Alex make a good decision, the team of us that are here on the line today. So let's kind of look at this. Okay, so for protection from probate, what would happen if Alex decides to do nothing and suddenly passes away? If you know the answer to that, you just quickly put your hand up, and you can answer. Well, unmute your mic. You guys have control.
Goes to the court.
Okay, so it will go to the court. That's correct. The probate court will have access to, if Alex passed away, the probate court would take access to whatever Alex has. And at that point, without an estate plan, he goes through a lengthy or potentially lengthy and public process that can be very costly. And who pays the cost of that? Does anybody know? Well, it's Alex's estate. The money that Alex may have left for his heirs, his wife, and all of that, that is where the money comes from to pay the probate court. So before they can even get access to the money, the probate court will be chipping away at Alex's estate because of the fact that he did not leave instructions in place. So let's talk about it this way. After Alex has learned about probate, he considered writing a simple will. While a will specifies Alex's wishes, will it actually protect him from the probate process? No, it will not. Okay, because the assets will still go through probate, although the process might be slightly more straightforward, it still is going to have to go through probate because he did not leave in writing instructions in a document that is respected by the court as a living trust. So here's another thing. Alex learns about living trust and decides to create one, transferring most of the assets, but he forgot some, and he never funded his living trust. Will Alex be able to use this living trust to protect him from probate?
No.
No, he will not. That's correct. Thank you for that, Crystal. So, the assets in the trust could avoid probate if he had funded the living trust. But if he doesn't fund the living trust, it doesn't make it real. He has to not only get it notarized, but he has to open up an account. Some $25 needs to be placed in there, but he needs to have something that is considered to be funded, and he needs to transfer assets. Even if he doesn't open up a bank account, he could transfer his home into the living trust, and that would be considered a funding of sorts. So understanding that the forgotten assets must go through probate, highlighting the need for more thorough planning. Alex could have done something else, and let's talk about what that is. Alex creates a living trust with a pour-over will, ensuring all of the assets are included. And when he does this setup catches any forgotten assets through the pour-over will, which directs them into the trust and helps him to avoid probate for his entire estate. So that's a complete and total process, okay? You set up the trust and you set up a will to catch anything that was left out or that was purchased or accumulated after the trust was set up, okay? So now let's take a look at some other things. All right, Alex opts for a simple will. Even though he learned more about this, let's go back a little bit. And he just decides, you know what, I'm just going to put together a simple will. I think this is, going to be enough for me. Will he be able to pass on his assets to his heirs with a simple will? Maybe, maybe not. So let's look at why he might not be able to do it. So the will provides clear instructions, but does not avoid probate. So it delays asset distribution and incurs costs. What if the costs of probate exceed what Alex left for his heirs to take advantage of? Well, in that particular case, then they may not get what he left, okay? So when we look at after the research, he considers the joint ownership for certain assets. Will this particular way help him get the assets to his heirs? Okay, he could, give his children or his spouse co-ownership to some of his assets, and will that help? And I want to be able to talk about this because this is really important for you to understand. Some people say, well, I'm just going to put the property in my children's names. But even though this avoids probate for the jointly owned assets, it can create complication if the co-owner has a debt or legal issues. What if they owe child support or some other thing that makes it such that now if the property is sold, they cannot get access to what it is that you left, because now their debt, it becomes the debt of what it is, or it goes against what it is that you provided to them, okay? And what if it was for them and their siblings, and their name is on it? That becomes a real issue. So you might want to think about that a couple different ways when you're thinking about co-ownership. I've seen some parents recently make some really good decisions about the co-ownership thing because they thought about divesting themselves of ownership so they could take advantage of their Social Security, which we talked about in our last session that we talked about legacy, how you could divest yourself of ownership of your property and, enough of your cash so that you could still take advantage of Medicare and Medicaid. Well, in this particular scenario, people have, divested themselves of ownership by giving the ownership over to their kids. But when you're thinking about that, be thinking about the fact that they could very well lose the house if they have debts or other legal issues. So by putting it in the trust, it protects it from their issues and still may give them access to it as well because it's still in trust. Okay. Now, beneficiary designations do bypass probate for accounts that um, are set up for your heirs. However, I want you to understand that the living trust does not protect your properties from creditors. So if you are thinking about utilizing the living trust and you have some creditor concerns, you might want to back that up with an ultimate beneficiary of your family trust, because the family trust is irrevocable and it gives you options that, to have the property protected in a way when you pass away that will make it so that probate and creditors are taken care of. All right. Okay. Gloria has shared that, there is there's a client that she has that has a similar situation. And, so one of the things that Crystal's made a statement about there being a possible lien on the property. Yes, that can happen. And so when you put the property in the irrevocable trust or put it in the living trust, and then it flows from the living trust to the irrevocable trust, because in a lot of states, the living trust, along with the homestead, will protect the property from being, affected by creditors. But when you pass away, now it's vulnerable. So if you have as the ultimate beneficiary your family trust, then you can take advantage of some of those other protections that are there to protect against creditors, because the family trust is not you. It has its own social security number, if I can say it that way, or EIN number. It is its own entity. And as a result of that, it does not have the issues that you might have in having the property affected by creditors. Okay. So one of the questions that is asked, or not, it's not really a question, but it's a statement, but I want to just back this up and say that, yes, if a person has a family member that has been diagnosed with an illness, and they are looking at, the possibility of them having an untimely demise, it really is important for you, as if this is your client or someone that's close to you, make some suggestions that they start looking into their estate planning, because there are things that they can do to take advantage of certain provisions that may be available to them. And by setting up the living trust, it gives clear instructions, and even, having the living will, which are, we kind of talked about the difference between what the living trust is and what a living will is in a previous session. But let me just say this, the living will is instructions as well. It's not a trust, but it's instructions to the healthcare professionals that will tell them what you would wish to happen, in case of you having some illness where you can't communicate clearly what you would want, or you need to designate someone else to operate on your behalf. So you want to, have those advanced directives there available for medical professionals and others, so that they can make sure that your wishes are followed if you are ill. But that's not in the trust. That is a separate thing. So I just want to make sure you do, know that in the living trust, you can designate who you want to make decisions, but the actual decisions, are put in another document called a living will. Now, designated care for minor children. This is a big deal for some people. And I remember when I was younger, I was in my 40s, I had a really bad illness. And it was something I had been born with, but I didn't even know I had until I had something to occur. And I found out that I had this particular illness, and I've been healed of it now. But at that time, it was, pretty interesting to try to figure out what I was going to do, because I had minor children, and I was pretty debilitating. It was pretty debilitating for me, because I couldn't drive for a while, and there were lots of questions about what was going to happen and whether or not things were going to be in a position where I would be able to make decisions because of what was going on with my body at the time. And so I had to, you know, put something in place because I couldn't assume that my family members would step in. I was in a position where I was not close to where they were. And for that reason, I needed to be, you know, really clear about what I wanted to do. I mean, formal action had to be taken. I had to have something written out so that if something happened to me, there would be some guidance, okay, for the decisions that were going to be made for my children. So, you know, I decided, you know, that I would put a guardian in place, thinking that that was something that was really going to help. And I later found out that the guardian itself, even though it's something that I chose, it would still have to go through probate. And so I didn't realize, because no one had taught me in, you know, in these matters, and I hadn't, you know, had any interactions with any legal professionals, that I could have delayed the guardian's appointment if I had passed away by just making a guardianship document. But having had a trust, you know, if I set up the trust and specified a guardian in the trust, it would, and then this particular way, manage the children's financial needs and stipulate what would be done about their day-to-day care and guardianship. So it's very important that if you are creating, you know, your living legacy through your living trust document, that you specify a guardian, and that you also specify in the pour over will this person, you know, if you need to make sure that you have a backup, because sometimes there are complex issues that happen in families. And if someone passes away, some family members may feel like they get to stipulate what you would have wanted, and they will try to weigh in, even though you might have wanted something different. And so this way, when you have that information in both the living trust and the pour over will, people can be very clear of what your wishes were. This comprehensive approach ensures that your children's financial needs are met without probate delays, and it clearly designates a guardian, providing stability and what we call continuity. You've heard me probably use that word more times than not, you know, but it's very important that there is continuity of care, you know, for your children. Okay, so now let's kind of talk about the business aspect of this, because it's really important. And it's the last thing that we're going to share today. But, you know, you want to really be thinking about the fact that when you are the principal in a business and you don't leave instructions for the business, sometimes things can go very differently than what you would have liked. And so some people have, you know, sole proprietorships, and others might be in a partnership or a general partnership, or they may be members of an LLC, or even for that matter, they may have originated the LLC or corporation. And in those particular different business structures, there are different types of documentation that would be something a person might need to have. So let's kind of look at it this way. You know, when you are a sole proprietor, generally you go down and file a fictitious business name statement and you just start doing business. But in terms of business documentation, there will not be any kind of formal bylaws or any type of document that's a governing document for your entity. So people may not know what your wishes were with this particular company. And unfortunately, because the company is you in the eyes of your commercial code in most states, then if you pass away, your company passes away as well. You know, so you want to kind of look at that and see the exposure that's there and think about, you know, is this what I really, really want to have happen with my business? If you have an LLC, you usually have what's called the operating agreement. And in almost every state in the United States, it's required that you have this operating agreement. The operating agreement actually usually states, you know, how the company got started and who put what assets in and who has, autonomy to run the company, how the company is structured, and what would happen to the company if something happened to you and or any of the other members, how the actual membership or ownership beneficial interest in that company could be passed on to your heirs and assigns. In other words, it could be assigned for someone to take your position in the company, or the assets that would be due you, upon the company's closing, someone could be designated to receive those on your behalf. Or for that matter, your profits could be designated for them to receive. So that's usually stated in the operating agreement. Okay. But sometimes it's not, and it's not very clear what you might have wanted someone to do. Maybe it's in there that it could be passed on, but you don't leave instructions as to who you would want someone to pass it to. So with that stated, this succession planning for business is really, really, really important, because if you leave the business's future uncertain without a clear plan, the business could suffer disruptions, and it could negatively affect its value and the livelihood of employees. And so you want to be very clear about the fact that if something happened to you, what you would want to be done with your beneficial interest in a company. And the same would happen in the corporation. The corporation has bylaws that gives permission for the company to pass on a person's shares to their heirs, or to assign it to a specific person. But if you don't leave a name, then they won't know who that person is. So by putting that information in your living trust, you give the trustee permission to communicate in a legal way with legal tender, some sort of documentation, okay, that's a same as cash transaction. So you want to be paying attention to that while you're, setting and structuring these particular things up. Okay. And then lastly, sometimes you might have a buy-sell agreement with your partners. And the buy-sell agreement does provide a plan, but it doesn't cover all aspects of succession. So, and particularly, if you got a buy-sell agreement with someone and you're a sole proprietor, it really doesn't cover all of the aspects of succession. So it's important for you to integrate into your business the living trust process, so that you can designate not just the tangibles, like maybe your furnishings and your gold and your silver, your financial instruments and things of that nature, but also consider the fact that your business is an asset too. And so you want to make sure that you leave good sound plans inside of your living trust for what you want done with businesses that you may have ownership interest in, and you want a smooth transition of the business, avoiding, probate, and preserving the value as well, so that you can secure the future for people who you've connected with in business and decided to move forward. Well, with these things, I hope that you've been able to get a really good view. I want to leave a couple of minutes for questions. So if anybody have a question or has a question, please, feel free to unmute your mic and jump in here and ask while we are talking about this particular very important area of your estate planning.
Hi, I have a question. This is Danita.
Okay, Danita.
Hi. So as we were going through guardianship, so I have my niece who is a disabled adult, and I'm wondering, would I put her in the living trust also as who would take over her care?
Yes, absolutely, Danita, because you have right now, your niece is like your child. Okay.
Right.
So,
I'm her conservator.
okay. So you need to designate Okay, unless some other documentation has been done to designate that what would happen, to your niece if something happened to you, you need to designate what you would want done. If you're the person and it's a tag you're it kind of situation where, you just received her because of the fact that she no longer
Right.
has parents, and now you are the person that are, operating as her parent, then yes, you have to, think about what it is that needs to be done for her and put those things in place.
Okay, great. Thank you so much.
And make sure that, because in every state, conservatorship has rules. So you want to make sure that you're following whatever those legal processes are. Because to give you an example, today I'm in Texas, and that's kind of my home state. And in Texas, the rules for conservatorship are very different than they are in California. In California, what would be considered a guardianship issue is actually a conservatorship issue here in Texas. So,
Really?
yes, and I have been in a position where I was co-parenting my grandchildren with my daughter, and at one point in time. And so, as a result of that, the conservatorship, there's a whole process here that you have to go through. There in California, you can drop a document, have it notarized, and you're fine. Here, it is a court process. Yeah.
Oh
Okay.
no, it
Yeah.
was a process.
Oh, yours, it was a process as well? Okay.
Because I had family. Yeah, so it was a
So
process.
this is interesting because when I had to do the guardianship process in California, it was really literally just I made a decision. I wanted my mother to be guardian if something happened to me because I was too ill to take care of the children at that time. And I drew up the documents. We went to, have the durable power of attorney drawn up, and we notarized everything according to what the courts, offered. I mean, for us to do at that time. We lodged everything we needed to lodge in the courts, and that was it. In Texas, not the case. Okay. So, but I do know that if there's somebody that's contesting, that changes things as well. So, I understand that too. Anyone else?
I just want to say thank you for your words of education.
Oh, you're welcome, Francisco. Thank you for being on the line. And I did see your information. Okay, this doesn't have anything to do with legacy, but there are people on the line that are concerned about or thinking about your 990s. I know I have some nonprofit organizations who are on the line. And I know that today, and I say on the line because some people are here via telephone and others are here via Zoom. So, do understand that we've got several people coming in from many different ways. But the 990s are not due until May 15th. So we will be talking about those in our first Thursdays. Those of you who are wanting to know a little bit more about our schedule, you can go to our website and to go to redworldwide.org and click on the calendar link in the menu bar. And there you'll be able to find out when other sessions are going to be held for different types of things. And so we do a first Thursday set of classes for the for the nonprofit organizations and for the LLCs. Right now, we'll be doing other structures as time goes on. We'll be adding the limited partnerships and general partnerships, and we'll also do some sessions for others who have unincorporated associations and things of that nature. But for the nonprofit organizations, we're going to be going over the 990 process on the first Thursday in March. We'll be talking all about tax and what it is that you need to have in place for your 990. And if you're going to participate with our free program, if you're less than $50,000, we'll file your 990 for you. If you're a RED member, please be on that call because that will give you the opportunity to take advantage of, gaining all the knowledge of what you need to put together to be able to participate in getting your 990 in file for free. Okay. Well, with that said, is there's not any other questions? And let me give one more opportunity. Oh, good. Okay.
Okay, do you have those services in Spanish?
Oh, awesome. Good question, Gloria. And it sounds like that's an opportunity for you to come help because
Well,
although,
because this client called me yesterday and I spoke with them last year to add the wife on the house and title. For
yes,
whatever reason, didn't work. I guess they're busy. And now yesterday she called me really worried that they diagnosed her husband with cancer and he's gonna have surgery in April and she needs to get this done. But she wants to add herself on title. But I was like, what you don't, instead of doing that, why you don't just do a trust, a living
right,
trust?
and put the house in the living trust. Yeah. So let's, rather than try to solve that, process, and under such duress, sometimes people make a decision to move themselves onto the property because of the fact that someone's ill, and doing so, the steps are missed. So, you want to, try to guide them. It'd be great to have them in a consultation where we can provide them some guidance, and then if we need to bring in some legal representation to talk with them as well, we can do that. So let's get them offline, and get them into a session so we can kind of share. We do provide those services for free, and so it's not a situation where they would have to, necessarily pay for the trust. But we want to make sure that it's the best decision for them. And, under these particular circumstances, we may need to involve, some legal representation. And we do have people that donate their time to help, RED members, with legal, consultations and things of that nature. So we can talk offline about that, Gloria. But yes, I mean, it is very, very important that if, a family member is ill, that you are, you do this in an expeditious manner, that you don't wait. We've had great success. And, thank God that we've been able to assist people who are in this situation. But for whatever reason, we were right there at the time and we were able to save them from losing a property, or for that matter, having to go through probate, or, we've been able to help them, understand how to move the property, in a way that was a better solution for what they were trying to do. So this would be a great time, to introduce them to the process. And I would love to have you on the line to translate. Yo hablo mucho español, pero no, yo necesito más ayuda.
Más práctica. Okay, thank you.
For these, because the words sometimes are really a lot more, there's a lot more words that I would need to say that I know how to say. And explaining every part of that process. So
Okay,
having
sure.
someone who it's their native language, they can say it better, than I
Okay.
can. Yeah. Okay. Wonderful. Anyone else? Well, this has been wonderful today. Thank you for joining. I hope you guys learned a lot. And of course, this is in no way to replace any legal advice. This is all educational. So please do understand that the information that we bring, is information that we believe is the most factual at the time that we bring it. And it's because it's of an educational nature, and because it's sometimes the commercial code changes, the Internal Revenue Code changes. Be aware that there may be changes, to what we're talking about over time. So please check with your legal professionals and your tax professionals and make sure that, when you're utilizing any information, you always are trying to have the most current information that's available at the time. Okay? And we'll see you next time.
Thank you.
Absolutely.